Hi, everyone. Thank you for joining today's Product in Focus webinar, Prosecution Data for Profit, 5 Tips for Making the Most of Prosecution Analytics. I'm Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to welcome you to today's event. A few things before I introduce our presenter. First, please submit your questions during the webinar by using the Questions tab in your console. You can also download a copy of today's slides in the Handouts tab. A link to the recording from today's presentation will soon be sent to you. Now I want to introduce today's presenter, Megan McLaughlin. Megan is the Product Director for LexisNexis Patent Advisor, a suite of patent prosecution management tools. Previously, she worked as a patent attorney at the law firm of Nutter, McLennan, and Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. She is the co-host of the podcast Better Patents Now, which explores topics related to patent law and prosecution analytics. And with that, I'm going to turn it over to you, Megan.
Thanks, Gail, and thank you everyone for taking the time out of your day to listen to me talk about prosecution analytics. So, as Gail mentioned, I'm the Product Director for Patent Advisor. Patent Advisor is a prosecution analytics tool that helps you make better prosecution decisions. And when you think of prosecution analytics, you're probably thinking about examiner statistics, because that's what most of them are. You know, what is Jane Doe's allowance rate? How many times does she allow a case after an interview? And that's definitely where we started when we built this tool about 10 years ago. Because when anyone first starts to look at USPTO data, the thing that's immediately going to jump out at you is how different outcomes are for different examiners in different art units in different parts of the USPTO. And this is an outcome variability that we discussed in a previous webinar called 5 Tips for Better Prosecution in the World of Big Data. It's recorded, so you can check it out if you didn't get a chance to listen to it. And this outcome variability, it's the reason that we created Patent Advisor in the first place, so that if your application ends up with a guy who hasn't granted a patent in a year, you know. And it's also why 10 years after we created the product, you see examiner statistics everywhere. So in the last webinar, I focused on how you can actually use these statistics to be a better prosecutor. You know, these are tried and true strategies for getting better at your job. I tend to think of these tips, the use of examiner data as like a prosecution analytics diet. You know, if you regularly make sure that you look at this data, you will eventually become a better practitioner. But we're 10 years deep into this data. I personally am 4 years deep into this data. And we're starting to learn that a lot of new things, specifically that there's more value in prosecution analytics than just examiner statistics. And in fact, some of the most high value insights come from looking at things like prosecution performance for a law firm or for a company, or from combining data about prosecution with other data sets like litigation data. Now, the value isn't always as obvious, doesn't jump out at you like the outcome variability that you see in examiner statistics, but there's definitely some gold nuggets if you know where to look. And the other thing that we're starting to discover is the relevance of prosecution data to things besides prosecution. So, you know, it's obvious that data about how prosecution has gone in the past is going to impact how you should do prosecution. But what's not so obvious, and that we're finding more and more, is that it's valuable for other use cases. It's not too surprising when you think about it. You know, what you put into a patent is going to affect what comes out on the other side. So these are the things that we're starting to learn now that we're about 10 years deep into this data. You know, I think that the industry has very much accepted the fact that examiner analytics are important, that you need them to be able to practice. But what I'm going to talk about today are some of the more up-and-coming trends, the ways that people are using analytics that I think are going to be the next wave in the next few years here. So before I actually get started, I want to turn it over to Gail to take a poll. I just want to know how many of you right now are using prosecution analytics for anything besides examiner statistics. So how many of you are using prosecution analytics for other use cases, you know, competitive analysis, licensing opportunities, patent valuation? So So I'm going to leave the poll open for just a minute and see if I can see it. All right, so it's collecting responses. Wow, okay, so that was quick. So already I can tell the vast majority of you aren't using prosecution data yet for anything besides examiner statistics. Like over 80% of you are not, and only about 20% of you are using prosecution data for things other than examiner statistics, which confirms what I've been seeing. You know, I feel like this is really the next new wave of how this data is going to be used. And honestly, I think that there's even the use cases that are not prosecution, that are not related to examiner statistics may actually even be higher value than those related to examiner statistics. So with that, I'm going to go ahead and jump in to the first tip, which is probably the most important thing you can do with prosecution analytics besides using your examiner statistics is self-analysis. You've got to know where you stand. Are you better than your competitors? Are you worse than your competitors? So what I'm showing here, this is just a benchmarking analysis that you can perform in Patent Advisor. By the way, all of the use cases that I'm going to be showing you today you can do in Patent Advisor. I'm not going to actually go into the tool and show you how to do them. There'll be some contact information at the end of the presentation, so you can reach out to someone if you want more specific guidance on how to do any of these things. But all of these are things that you can do within the Patent Advisor tool. So what this is something that we call an alignment report. It just compares prosecution of performance of various entities, either law firms or companies, within any given technology area. So in this case, this is looking at Art Unit 2879. These are actual law firms, which I've anonymized, and this is their performance. So if you, for example, are law firm G, you would definitely want to know that you're actually doing better than average, and you're doing it without ever having to resort to the appeal process. So if I'm law firm G, this is something that I want on the front page of my IT practice website. And if I'm a company hiring law firm G, I also want to know this because maybe I want to actually direct more cases to this law firm. Maybe I want to take some cases away from law firm B, who's got a pretty low allowance rate, a high percentage of RCEs, and they're still filing a fair number of appeals. I've often thought, wouldn't it be great if, you went to the doctor if you had to go to the doctor for some reason, you could know what that doctor's success rate was with similarly situated patients. And obviously there's like a million ethical problems to that kind of approach, but as IT practitioners, this data is actually available, whether we like it or not. So other people are out there looking at this data about you. So you want to be armed with this data first, because if others have it, you obviously want to see it. One big caveat that I want to point out, obviously I think reports like this are great, but a word of caution if you're presented with something like this, these reports can be massively misleading if they're not done correctly. Just to give a few examples, if you're comparing law firms in different technology areas, that's like comparing apples and oranges. You can't compare a law firm that practices primarily in software to a law firm that practices primarily in the mechanical arts. That's just not fair. I opened up talking about outcome variability at the patent office. We all know that's a reality. So if your comparison is too broad, it may not be meaningful. And there are a bunch of other reasons that the data could be misleading. It could have to do with how a law firm is defined. We go to great lengths in our system to make sure that we know who the law firm is in every single application. And it's not that easy of a thing to do. You have to actually look at a bunch of different documents in the image file wrapper. So, if the law firm isn't defined correctly, that can be an issue. So you always want to make sure you understand the data behind these. And I think that these are a really good starting place for a discussion, but they're not necessarily the end of the story. I think they're useful for highlighting major issues. They can be incredibly useful for law firms to distinguish themselves, but they're a starting place for the discussion. So once you know where you stand, it can be helpful to understand why you are where you are. So another thing that you can use these prosecution analytics to do is a little bit of internal portfolio evaluation. Now, I know I said earlier that this webinar is all about moving past examiner statistics, but examiner statistics still inform a lot of the analysis that we do at the law firm or corporate level, because who the examiner is has a pretty significant impact on what happened in that case. So just briefly, I want to introduce you to a concept we call ETA. ETA is a way of measuring examiner efficiency, really. So a green ETA examiner, that's a very efficient examiner, and a red ETA examiner, that's a highly inefficient examiner. Yellow is everything in between. So green examiners, they're granting, anywhere between 50 and 100 patents per year. Red examiners, they're granting probably less than 5 patents per year. And yellow, like I said, is just kind of average, everything in between. So what you can do, if you know this information, if you know the ETA for every examiner in your IP portfolio, you can use this information to identify problem areas. And there's several ways you can do this. And I've just shown 2 examples here on the screen. So on the left-hand side, what this is a chart showing all the pending applications in some portfolio that have had more office actions than are average for that examiner, right? So if the examiner's average number of office actions to grant is 2, that some application had 3 or more, right? And what I've done is I've divided up those pending applications with spend over average into buckets depending on the examiner's ETA, right? So there are 3 pending applications that have spend over average with a green examiner and 49 that have spend over average with a red examiner. Not surprising, right? Green examiners tend to allow cases quickly. Red tends to take a bunch of extra time. So it's not surprising that there are more red applications with red examiners than green. But what this does is it immediately singles out for you applications that you really want to look into and question. If you have an application with an examiner who's unlikely to allow anything ever, frankly, do you really want to continue with that case? And so if you're the law firm working on this case, maybe you want to at least let your outside counsel, let your client know that, this may not be worth the fight. And similarly, if this is actually your case, you may want to circle back with outside counsel and try to figure out what's going on here. Same thing with the cases on the opposite end of the spectrum. So these 3 cases that are with green examiners, something's gone wrong here because green examiners are incredibly efficient. They want to allow cases and they want to allow them fast. So if your spend is over average, something is amiss here, and these cases are definitely something that require further investigation. Another thing that a lot of our customers like to do with using this ETA data and mapping it onto their portfolio is to compare the ETA of an application with its business value. So in our tool, you can upload any data that you want of your own. So you can, if for example, the individual attorney working on each of your cases, you can upload that information into our system. If you know the business value of your cases, say there's some kind of ranking, you can upload that into our system. So people like to upload the business value into our system and map it against ETA. And here's the reason. So if you've got a low business value case that's with a red examiner, that's something that you should immediately be questioning. If you're in a situation where your prosecution budget is tight, and I don't know if anyone in the United States is in any other situation right now, those are cases that you want to think about cutting immediately, because what's the point? And conversely, if you have, let me flip to the next one. If you've got a high business value application with a green examiner, that's something where you want to push your advantage. You want to know about that. That's a situation where you want to push the claims to be as broad as you possibly can, where you maybe even want to file some continuations. So definitely help with that business value against ETA, and divide your application pending portfolio up by ETA so you can help to identify what may be problem areas. Going a little bit deeper, there's 2 areas where I think self-evaluation is crucial, and those are use of appeal and pilot programs. Everybody looks at these statistics for examiners. In fact, I'd say appeal statistics are the #1 thing that people look at when they think of examiner statistics. They're trying to understand whether it makes sense to appeal this examiner or not, whether other people have appealed this examiner and on what issue. These statistics are examiner statistics are incredibly useful for that. But look at these statistics for your own law firm and company as well. How effectively are you using these programs? And I was recently doing a demonstration for a small corporation. They had a portfolio. They file like 20 new patents every year. And I looked at their appeal statistics, and I was so impressed. So I noticed immediately that they had a high percentage of applications with at least one appeal cycle. I'd say on average, the percentage of applications with at least one appeal cycle in any portfolio is around 10. It doesn't vary much from that. Below 10 is kind of low. 15.9% of applications having at least one appeal, that's very high. But the thing is, they're making excellent use of this program. If you see, they have an almost 80% success rate on appeal. And a large part of that is because they have fantastic results just from filing an appeal brief. So like most entities, most of their cases don't go all the way, most of their appealed cases don't go all the way to the board. They're pulled out of appeal before that. And a significant number of them were pulled right after the appeal brief. So 13 of their cases were allowed right after the appeal brief. 12 got a non-final office action. These people are writing amazing appeal briefs. And if this were my company or my law firm, I would want to advertise this. The other thing, and there's not information about this on the slide, but you can imagine how you would do the same analysis, is to prove your performance on pilot programs. I talked about this before, and you can find a lot of information about this pretty much anywhere, but pilot programs like Track 1 have really, really great success rates. Track 1 in particular, not only are you going to have faster prosecution, the USPTO guarantees that, and it's true, you're actually more likely to get a patent. The allowance rate for cases that go through Track 1 are just higher. Now, that could be because of self-selection. It could be because people only file Track 1 because the case is important. But for whatever reason, Track 1 seems to be a really good program. And it's funny, whenever I talk to someone on my development team who's not a patent attorney and I try to explain what Track 1 is, like, oh, you can pay a little bit more money and the USPTO picks up your case faster and it usually has an experienced examiner working on it. They all immediately ask, why doesn't everybody just do that? And I don't know. But the good news is the USPTO just recently increased the cap on the maximum number of cases that it'll accept under Track 1 each year. So if you are using this program, it's definitely something that you want to know. If you're not, maybe you should check on that and try to understand why, but it's a very successful program. And if you can prove that you're using it and that you're getting good results, that can be very helpful particularly for law firms to advertise their services. Okay. So perhaps you did this analysis and you've discovered that you're not the best in your field. Or maybe, you're doing pretty well, but you struggle in a particular area. Well, luckily, for better or for worse, there's really no secrets in this area because everything that your competitors have done and are doing is public information. So if you notice that one of your competitors is doing something better than you, this is one example of a quick check that you can do to see maybe why. So this is another analysis done in the tool, taking any patent portfolio, for example, a competitor's portfolio. You can limit it to look at only applications that have had patented applications that have had a few number of office actions. So they were patented and they were patented very quickly. And you can immediately see which art units they're filing in. So in this case, they had 81 applications in 2876, 34 applications in 2887, and so on down the line. And all of these are hyperlinked in the system. So you can actually click on it and see the list of applications that makes up that statistic. So one really easy thing you can do if you notice that some competitor is performing better than you is to understand where they're filing and where they're having success. Particularly if they're a competitor who works in a similar technology area, maybe you want to consider trying to get more applications in the technologies, in the art units where they're successful. In the previous webinar, I talked about a tool we have called Pathways that actually helps predict the art unit your application will be assigned, and it helps give you tips to draft your application so that it would be appropriate for review by the art unit of your choosing. So to the extent you have control over the drafting, you may want to consider redrafting your applications to get them into the same art units where your competitors are having success. To the extent that you don't have control over the drafting, maybe you're actually in charge of this portfolio, it might make sense to pursue more R&D in technology areas that are successful, assuming patents are an important part of your strategy. Or if you're in a position where you just have a million invention disclosures on your hands and you're trying to figure out which ones you want to pursue, maybe pursue those ones where others are doing better. So this can be particularly useful if you have a small portfolio or not much experience and you're trying to learn from others who've been out there longer. So another more granular way to piggyback off of others is by researching which arguments they've used which were successful. So this is a tool called PathAwk Search. What it is it's a text search of all substantive documents filed at the Patent Office since 2000. So you can do a full text search of office actions, claims, responses, appeal documents, etc. And you can filter that search by pretty much anything you can think of. So one thing that a lot of our users do is they'll search for a particular argument and limit it to maybe an examiner to see how that argument has worked for an examiner. But in the context of this webinar, I think what's interesting is to see what arguments have worked for one of your competitors. You know, if you find that you continually are getting stuck by the same issue, maybe it's the same type of rejection or the same prior art reference over and over, it might be interesting to see how others have overcome that. So you could limit the search to patented cases, responses and appeal, and search for the argument. And you can even limit your search to a particular competitor, whether that's an assignee or a law firm, to see how they've been successful or if they have been successful on that particular issue as well. So the last point was retrospective, right? What have others done that seems to work, that you want to emulate? But prosecution analytics can also help you stay on top of your competitors moving forward. It can let you know what's valuable to them, what's coming down their pipeline. It can even help you identify licensing opportunities. So if you're talking about bang for your buck for time spent with prosecution analytics, this may be the biggest tip that I can give you today. These are by far the highest value use cases. It may take a little bit of searching, but if you find an opportunity through this, it can be really valuable. So the feature that we have that's most useful here is called Prosecution Pattern Monitors. I know it's a mouthful, but basically what they help you to do is to look for any pattern that you might see in an application record. You know, and you can search for anything from examiner identity to something that may have happened in the file history to number of office actions. Pretty much any application feature you can think of, we can monitor for. So this monitor is just one example. It can help you find all applications filed by some competitor that had a request for track 1. Now this is particularly interesting because, you know, as I mentioned before, track 1, while incredibly helpful and valuable, isn't very commonly used. So if someone's paying for track 1, I think you can pretty safely assume that they value that patent. It probably has some kind of high business value if they were willing to pay that extra $5,000 to get it through the patent office quickly. So what you could do is you could use this monitor to check and see every time a competitor files an application that used the track 1 program. So you can see I've set up a condition to look for this particular document in the file history, a request for track 1. You could also look for the track 1 grant if you wanted to, or even both of those documents if you wanted to, and you could set a time range on that. And then once a week, it can send you an email that says, hey, your competitor filed this case with track 1. So you can think of these like any kind of standard patent alert that you might be interested in. You know, I think the industry has long been using alerts just to know, you know, when their competitors were filing applications. It's like that. It's got a tiny bit of delay. Sometimes it could be up to a week, but it can look for all different kinds of specific patterns. So you're not just learning about every single new application that's filed. You're learning more about the important ones. And along those lines, another option along the same lines is to monitor for applications that are likely to be coming soon. So like I said, I think most of us out there have alerts for new filings by competitors. And we're actively monitoring these to see what's going on. You know, every time there's a response, every time there's an office action, you got to pull it up, you got to see what happened, you got to review the new claims. You might be able to save a little bit of time and effort on this by monitoring more intelligently, right? We all know that some applications are infinitely more likely to languish and die at the patent office because of the examiner that they've been assigned to. Why would you waste your time on those? So this monitor singles out applications that are likely to issue soon and with few changes to the claims. These are applications that you want to get your eyes on immediately. These are applications that are filed by your competitor that have been assigned to a green or efficient examiner. So remember from our discussion earlier, green examiners are highly efficient, granting maybe over 100 patents per year. So if this is a patent that matters to you for whatever reason, you want to know, because it's basically just been put on the fast track for allowance. So that's more. So those monitors, they're a little bit more of a defensive move, but we can help you go on the offense too. So remember the image file wrapper search tool I mentioned earlier that you can use to search for arguments? That is still what most people use it for. They're using it to look for arguments, rejection types, etc. But people are also starting to use it to search for examiner or applicant mentions of their IP. You know, it's one thing if your IP is cited in an IDS along with like 10,000 other references. Obviously, it's still useful to know, and you want to know that. But it's an entirely other thing to know when your IP is actually blocking someone else's patent, and that's what we can help you do. So in this example, I'm just searching for a patent number. You can limit the results to look for citations by a particular, by a particular examiner, a technology area, or an assignee, or you can just search for any citation whatsoever. And then the results will include all office actions and responses that mentions the patent number you're searching for. So you obviously have to do 2 searches per patent, one for the publication number, one for the patent number. But then what you find are situations where your patent is being used to block another patent. Now, I mentioned everything that I'm showing you today you can do in the tool. This you obviously can do in the tool. If you want to do a bulk search, if you want to search the image, all image file wrappers for all the patents in your portfolio, that's actually something that we would have to do as a separate service, but it absolutely is something we can do. So, and we can even do it on a recurring basis, monthly, quarterly, yearly, as often as you want. So you can keep tabs on when your IP is being cited against others. So obviously this can be incredibly valuable for licensing opportunities. Even one good hit here can make a big difference. So the next tip is interesting because it informs prosecution strategy, but it does so by combining our prosecution data with litigation data. So some of you may be familiar with Patent Advisor's sister product, Lex Machina. They basically do what we do for prosecution, but for patent litigation. So where we offer examiner profiles with examiner statistics, they offer district judge profiles, showing which cases they've allowed, features of those cases, outcomes from those cases. Now, our goal was to try and understand what happens when you combine this data. So how does what you put into the patent during prosecution affect how it fares in litigation? Questions like where do litigated patents even come from at the patent office? Do they come from a particular art unit? Do they come from a certain type of examiner? And what things can you do in prosecution to ensure that you get better litigation outcomes? We'll never be able to fully answer this question, and because there may be no answer to it, but we can at least provide you some data to give you some tips on how to prosecute patents that are going to be more litigation proof. And we can do that by helping you to find correlations between successful litigation and prosecution factors. Now, we just recently incorporated this litigation data into Patent Advisor, so it's just still very new and we're still learning, but we're already seeing some really interesting correlations. Professor Shine Chu at the University of West Virginia, actually even before we did this, did a study on his own on that question that I mentioned, where do litigated patents come from? What he found was that they come primarily from primary examiners, which makes sense because primary examiners with primary status are putting out the most patents. But what the interesting thing he found is that a disproportionate number of litigated patents come from examiners who are just transitioning over to primary status. So that's one interesting USPTO-wide piece of information that we've already discovered. But for the most part, the correlations that we're finding so far, they really vary by technology area, which I guess is not surprising given that pretty much everything at the Patent Office seems to vary by technology area and even by examiner. So, but we give you the tools to figure out where those correlations are and what they are. And one particularly interesting one is between the number of office actions or the length of prosecution and how successful litigation is. So when I was practicing, which was a while, already 4 years ago now, I was taught that you keep the prosecution record to a minimum. You say as little as you possibly can because everything that you say can and will be used against you, right? But since working in this field, I've started to hear the exact opposite, which is that a strong prosecution record is likely to be respected in court. The judge is going to look at that. Oh, well, the examiner looked at this for 10 years, so clearly there's no art that he found that I'm going to find that he hasn't already looked at. So, what's the truth? Like, which is actually better? Which actually leads to better prosecution outcomes? Now, I can't fully answer that question, but what I do know is that at least in this one technology center group, 3690, this is one of the homes of business method patents, so a ton of 101 rejections here, fair bit of litigation. In this particular area, what we see is that patents that have had very few office actions actually have better litigation outcomes than patents that have had more office actions. Oh, I'm sorry. That's not, yeah. But so fewer office actions leads to better litigation outcomes in this context. I get myself confused because I found the exact opposite in certain other technology areas. So it's important to check up on which technology area you're looking at. But at least in this area, it does seem to be true that that you want to have a little bit of a shorter prosecution. Now, there could be other factors behind this that I haven't accounted for. It could be because of a particular type of rejection. I haven't done the research on this, but you can. You can even do this for an individual company, a law firm, an industry area. One of our more litigious Asian customers just did this recently. This is not their data. This is just an example of what they did. But what they did was they printed out a spreadsheet from Patent Advisor with over 100 prosecution features for their applications. So number of office actions, was there a restriction requirement? Were there certain types of rejections? Was there an appeal? And they did two spreadsheets. They did one for applications that had gone through litigation and had had favorable outcomes, and one that had gone through litigation that had not had favorable outcomes. And they found out where the correlations were. So I won't tell you what they learned, but I can tell you that they did find one thing that was happening in prosecution that was very correlated with bad litigation outcomes. So they're not going to be doing that thing moving forward. So this is a very technology area specific, maybe even company specific analysis, but it's worth doing if you care about your patents standing up in litigation. It's very much worth doing if you're planning on actually asserting your patents at some point in the future, because there are correlations. They do vary, but there are definite correlations that you might want to be aware of. So finally, this is probably the most cutting edge use of prosecution data that I'm aware of. And I know this can be a little bit controversial, but people are starting to use prosecution data to value patents. So over the course of my work at this job, every once in a while, I'll be approached by somebody who's trying to use Patent Advisor for due diligence. But I'm starting to see more and more interest in this, particularly in the financial sector. And it's not a surprise because, it's a big problem. There's 1,000 papers and products on valuing granted patents. We offer one, it's called Patent Site. Obviously, it's the best one. But what do you do before the patent is granted? How do you value a pending application? And this is a really big deal, particularly if you're a startup company and your IP is your only asset. It is what it is your whole value. And when we're seeing increasingly that IP is a greater part of corporate value worldwide. So how do you deal with these pending applications that haven't even granted yet? Now, right now, what you do is you have an attorney review the claim. And I'm not suggesting that anything here can replace that work. An attorney's evaluation of the claims is obviously very important. But we do have prosecution factors that can shed some light on what is otherwise a pretty big black box. So at a minimum, if a pending application is with a red examiner, remember, a highly inefficient examiner, less than 5 patents per year, maybe that application shouldn't be considered to be too valuable. If you're a startup company and you've only got 1 or 2 applications and they've been assigned to a red examiner, that's not good. And then, of course, on the flip side, if your application gets assigned to a green examiner, that's an incredibly good sign. Again, it's like you've been put on the fast track to getting a patent. And moreover, you're likely to get a patent with fewer amendments to the claims because it's not going to go through as many rounds of prosecution. Now, the analysis on this slide is showing an analysis for a company's entire pending portfolio. So you can do something clever where you assign a certain number of points to applications that are assigned to green examiners, a lower amount of points to applications assigned with yellow, and then maybe no points to applications assigned to red. So you could even come up with a composite score for an entire company. If you're very conservative, and this is what I've seen most customers do, pretty much they just red flag applications that are with a red examiner. It's in the course of due diligence, as you're looking for red flags, are there liens on the patent? This can just be another red flag that you place. Well, they have a high number of applications with red examiners. So really, are those any value at all? So you could do this analysis by overlaying any number of prosecution factors onto a pending portfolio. A number of office actions, whether or not there was an appeal. I won't get into my opinions on which prosecution factors are correlated with high value. I know some people think that long prosecution is actually correlated with high value. Others will argue that low prosecution is correlated, or short prosecution is correlated with high value. Whatever your system, you can use Patent Advisor to score pending applications based on these factors. And you can even use these prosecution factors to supplement your valuation of granted applications, particularly if they're brand new granted applications, then you might not have that much of an idea yet because they just haven't been out there long enough to be cited. You can use this analysis to supplement the valuation of an entire portfolio, whether it's granted or pending. And again, there's a bunch of prosecution metrics that could be tied to value. Could be the examiner's ETA, presence, absence of appeal, certain types of rejections. So again, this is something that's very new. People are just starting to get into this, but I definitely think that this is an up-and-coming trend and that we're going to start seeing more of this moving forward. So now that I've shown you these tips, I want to turn it back to Gail. Gail, can you launch the next poll? I want to see, of these tips that I've shown you, which one did you think, if any, was the most valuable? So of the 5 tips, and I can run through them really quickly just to remind you, know where you stand using prosecution analytics to try and understand where you are with respect to your competitors and where your problems may be, emulating other successes, finding out where they're successful and trying to do like them, monitoring your competition, aligning prosecution strategy with litigation outcomes, and assigning value based on prosecution factors. So the results are coming in so far. Oh, wow, it's changing pretty rapidly. Okay, so it looks like there's pretty much a tie for the first 3 factors. So knowing where you stand, emulating other successes, and monitoring your competition. And then in second place are the last 2. So aligning prosecution strategy with litigation outcome and assigning value. But it's a very close tie. And it makes sense because I kind of went through this in the order of trends that I'm seeing in the market. So the first 3 are things that I see more commonly. The last 2 are kind of brand new cutting edge things that I'm just starting to see now, but I expect will pick up within the next year or so. So almost exactly equal numbers for all of these, but slightly more, seems like slightly more people are interested in the first 3. So like I said, these are just some tips based on the trends that I'm seeing in the industry. I think the industry has long accepted that examiner statistics are valuable and that you need them to be a better prosecutor. And I think that if you consistently implement examiner statistics into your workflow over time, you will get better results, you will get better patents, and you will get them faster. But I do think that the actual highest value, the greatest value of prosecution analytics are actually in the things that I've been talking about today. And so I think in the next few years, you're going to see more and more of these types of use cases in the industry. So thank you all for attending today. I hope that you learned something valuable. If you're interested or if you have any other questions, please feel free to reach out to Morgan Connell or myself. Like I said, everything that I showed you today, you can actually do within the tool. So we'd be happy to show you how to do that in detail. And otherwise, I hope you have an excellent rest of your Thursday and that you learned something new today. Thank you.